Hello and welcome to the LRB. I'm Steve Miller, and with me here is Bob Nelson, a senior legislative attorney. Bob, the LRB has published a constitutional highlight on the Equal Protection Clause. Can you tell us why that provision is in the Wisconsin Constitution?
Well, interestingly, everybody knows what the Equal Protection Clause is all about. All men are created equal with inherent rights, such as the right to life, liberty, pursuit of happiness. That is in the Declaration of Independence. And it came into the Wisconsin Constitution when it was first adopted, that language, but in fact the U.S. Constitution doesn't have that language at all. It's only in the Declaration of Independence. Its job is to say you should be treating similar people similarly. So you shouldn't say blondes can do one thing and brunettes can do other things. That's basically what it's about. Finally in 1868, I think it was, 20 years after Wisconsin adopted its constitution, the federal government adopted the 14th Amendment, which says that no state may deny a person equal protection under the laws. And that's those two together now. Our Article 1, Section 1 and 14th Amendment are the basis for the equal protection provisions of the Constitution.
Of the Wisconsin Constitution.
Right.
So what has the Wisconsin Supreme Court had to say about that provision of our Constitution?
Well, what the court has said is they've looked at federal court cases, of course, because of the 14th Amendment, and they've said basically that we're going to have two different standards for determining how if a person have their rights violated under the Constitution under the Equal Protection Clause. One standard they call the strict scrutiny or heightened scrutiny standard, and that's the situation where some fundamental right, like the right to vote, the right to travel, the right to free speech, is abridged or of some kind of subject classification, such as race, gender. If that is being affected by the law, then the court has this heightened scrutiny, and they say that the law is only effective if it is narrowly put together, enacted for a very specific narrow purpose.
Mm-hmm.
If the classification is too broad, or if the purpose is too broad, the court will say it's unconstitutional. So that's one test.
But if there's not a heightened scrutiny, then what kind of scrutiny is there?
Then they have this language they call the rational basis test. And they say basically if the law is rationally related to a legitimate state purpose, mm-hmm. then they allow the classification. And they have standards that they've adopted over the years, basically 5 standards that talk about how you determine if it is rationally related. They're fairly simple standards, but the courts kind of put a little gloss on it. But basically it says you have to have substantially different classes. You have to have the ability for people to get into that class, so you can't have it stop now. You have to make sure that those classes are reasonably related to the purpose of what the act is about. Those are what they're really trying to get at. They're trying to make sure that if you're going to have classifications, those classifications relate to what you're trying to do in the act.
So there's a rational basis for the action of the legislature.
Right, that's right. It's an attempt to make sure that we don't just have arbitrary and capricious decisions about who's going to be within a class and who's outside that class.
Okay, and that's a Wisconsin Supreme Court that has decided that?
Yes. Mm-hmm.
Okay. So if the legislature is looking at a pending matter and they want to make sure that they don't run afoul of the Equal Protection Clause, what should they do?
Well, there's 3 things they should do. First of all, they should, if they're going to affect a suspect class, or if they're going to affect a fundamental right, then they have to very narrowly draft that law. So it only applies to a narrow situation. Obviously, the other thing is not to affect suspect classes and not to affect fundamental rights, just to leave those alone. So that's one thing they should do. The second one that we as drafters for them and they themselves have to look at is look at the Supreme Court decision and see if those 5 criteria are being followed. And those 5 criteria are being followed, then there shouldn't be any problem. The third thing that can be suggested to the legislature is that they broaden their class. They look at why do they really need these narrow classifications of people. Perhaps they should broaden them. I'm thinking of a couple examples where the courts generally will follow the rational basis test, but a couple of cases that I can remember that I've seen that where they haven't is quite indicative of why and how the Supreme Court does this. In one case, the legislature passed a law that said that in Milwaukee County, we're going to do environmental reviews in a different way than we do them in all the rest of the state. The court said, no, you can't do that. There's no rational basis for having different. Milwaukee County's not that different in terms of the environment of any place else in the state. So they threw that law out as not rationally related to the legitimate state interest. There was a legitimate state interest, but it wasn't rationally related to it. Another example was where they passed a law that said that architects and I think it was designers of improvements to property were exempt from tort liability, but other people that were involved with the construction, the contractor, the homeowner, were not immune from tort liability. And the court said again, there's no rational basis for this. There may be a legitimate interest to do, but there was no rational basis. So the court threw that one out too. So those are two examples of what they've done. And so the legislature has to try to make sure that they look at what they're doing and make sure the classifications are rational, related to what they're trying to do.
Okay. Thank you, Bob.
You're welcome, Steve.
And thank you for watching the podcast. If you'd like to learn more about this, look on the LRB website at Constitutional Highlights.